Welcome everyone to the second day of the third annual Pennsylvania Farm Show Agricultural Law Symposium. Our first day's program was on Tuesday, and I just wanted to highlight the content that we covered on Tuesday. We started by covering a year in review, highlighting legal developments from last year, and then talked about two cases that are pending before the Supreme Court, dealing with California's Proposition 12 and the waters of the United States. If you were unable to attend Tuesday's session, or if you want to look at the content again, or if you want to refer a colleague to that content, we should have the recording of that posted on our website probably by the end of next week. So if you do want to check that out or want to direct someone else to do so, please check out the center's website, which is at aglaw.psu.edu, and you can go to the Watch or Listen tab to get that information. Now today, the content that we have today, the first hour, we are going to focus on agricultural antitrust, which with a focus on the protein sector, looking specifically at poultry, pork, and beef, looking at the multi-district litigation. And then our second hour will cover two kind of ever-present environmental topics. The first being glyphosate and dicamba. The second part of that session will look at the Chesapeake Bay TMDL issues. So we will go from 1 o'clock to 2 o'clock. Dealing with antitrust, we'll take a 15-minute break, and then we'll come back and go from 2:15 to 3:15 on those environmental topics. Okay, so some of the logistics. Just once again, that this webinar is being recorded. As I just mentioned a few minutes ago, a recording will be available probably by the end of next week, both for Tuesday's session and Thursday's session. The materials are posted on our website. If you go to the events page, and you can go to this event, and the materials will be posted there. If you have any questions, please use the Q&A feature, and then we will direct those questions or address those questions at the end of each hour. Okay, I want to make sure that I thank our partners. The work of the Ag Law Center is sponsored by the Pennsylvania Department of Agriculture, and also we get substantial funding from the National Agricultural Law funding that originates with USDA's Agricultural Research Service, the National Agricultural Library within that agency. So we're getting funding for this program from them, and so we want to make sure that we are expressing our thanks to them for the support they're providing to us. So for our first hour today, the antitrust, the speaker is Brook Duer, who is a staff attorney with the center. He's been a staff attorney with us for, I think, 3.5 years now. And prior to that, Brook had a long tenure as general counsel, or long tenure with the PA Department of Agriculture, including a number of years as general counsel. Prior to Brook's time at the Pennsylvania Department of Agriculture, he worked in private practice, and so he brings a wealth of experience to the center. And those of you that have participated in our programs before, you're well familiar with Brook, or you're familiar with him from one of his past lives. So with that, I'm going to go ahead and turn it over to Brook to talk about antitrust. Thanks.
All
Brook.
right.
Go ahead.
All right. Thank you, Ross. Just double checking all my.
Yeah, I can see your PowerPoint.
Yep, and my mic's on.
It looks good. We can hear you. We can see
All right.
you. We can see your PowerPoint.
All right. Okay. Good afternoon, everybody. I'm going to talk about agricultural antitrust, and we captioned this as agricultural antitrust litigation. However, I put an asterisk on there because we're also going to talk a little bit about a brief review of selected executive and legislative branch actions or inactions that occurred in 2022. For those of you who were part of this same symposium last year, I did a similar shorter version of this, but did not have nearly the information at our disposal, and I will explain that in a minute. So this is going to pick up a little bit sort of in the middle of where we were last year, go over a little bit of recap, and then we'll get right into it. All right, now let me advance my slides. Okay, you know me, that's me. For those of you who don't, my email address is there. I'm always happy to take emails from people and try to dig up things for you. Today's focus is, I made this little sort of outline format here to sort of bring us down to exactly what we're going to talk about, and to some degree by doing that also exclude, make it clear what we are not going to talk about and what's sort of excluded from the scope of what we're covering today. Generally, ag antitrust litigation, we could be talking about criminal prosecutions, and there have been a number of criminal prosecutions in the protein sector, particularly poultry and pork. Some executives at some of the processors, for example, have been charged criminally. That would not be, there would be not enough time to go over that, and it's very, very difficult to get all the information on that. So we're not going to talk about criminal prosecutions per se. Now, civil litigation, that's why I got the X next to the criminal prosecution here. Civil litigation, of course, is what we're going to talk about, and class action litigation is generally the type of civil litigation that we're going to talk about, and it could be in state court. Sometimes that happens, but we're not going to be talking about state court cases, so that's why I got the X there. We're going to be talking about federally filed class actions, civil class actions, and we're also going to be talking about the next step down in my little diagram here is we're going to be talking about multi-district litigation, and that's quite a growing field. I have a statistic coming up here that is quite amazing with regard to how many. I saw this statistic. I think it's in my PowerPoint still, which was something like 70% of all the cases filed in the federal court system in the U.S. right now are part of some type of multi-district litigation that is coordinated in one district, even though it may be from all over the country, for example, and they put it all under one judge. We'll talk about that in a little bit, for sort of under one judge for the pretrial period, not the trials necessarily. And then within that multi-district litigation, we're going to talk about specifically the protein sector. Okay, now what I want to do right now is show you where on our website you can get the information that I'm talking about, and where you can see essentially the compilation of legal research that we've put together that we're going to go over today. So here's our website address, obviously, and then so you go here, we got the drop-down menus across the top. You see where it says research by topic, that's where you want to go. And under research by topic, you come up with a couple of choices, and there's more than these two, but this is the only two I can fit on the screen. There's ag law issue trackers, and that's where we want to go. So you go to that and just click on there, and then you're going to see ag law issue trackers, and you're going to see a whole bunch of photos with captions on them and ag statutes. For example, here is the agricultural antitrust litigation issue tracker. We had one that we followed the first 100 days of the Biden administration, and there's a whole bunch of them on this page. So that's, you're going to go there, and then you're going to see this, which is the actual top of the first page of the issue tracker, and over here is sort of the navigation mechanism for getting around, because you can go to, for example, in-ray broiler chicken antitrust. That's what starts here at the top of this page. You can click on these and go to different compilations that have to do with these topics. And so we're going to talk about, let me advance here. We're going to talk about these three areas, and particularly these three dockets that are in the multi-district litigation system. And in-ray broiler chicken antitrust, in-ray pork antitrust, and then there's one called in-ray cattle and beef antitrust. Much less developed on the beef, and I'll talk about that in a minute. It all starts with the broiler chicken antitrust, and that, as you see from the docket numbers here, that was filed initially in 2016, and then the pork was in 2018, and the beef was in 2020. And the beef is having its own little path, but the broiler chicken antitrust litigation and the pork antitrust litigation are very much mirroring each other. They more or less set the sort of the path in the broiler chicken litigation, and now the pork litigation is essentially following the same processes and really using the same entire approach. I'll show you some of that in a minute. However, now we're going to talk about those three cases, but before we do that, I want to go back a little bit here and revisit the other part, civil class action litigation based upon violations of antitrust laws in the ag industry is where that's the leader in this area, let's just say. But there are other things that are being pursued in the executive branch and the legislative branch. And I'm going to go over that in a minute here to sort of bring you around to understand what each branch of the government is doing. Now, interesting little side note before I go to the next slide. I went to the White House briefing. Actually, it was, the White House briefing room website. I put in the words, I searched meat processing, and I got 5 pages of hits, 50 separate documents on the White House briefing room website that came back when I just searched meat processing. Now, I find that unbelievable or somewhat odd that this has become an issue of that, or that's being discussed at that level of discourse, that, the White House briefing room where you see all the press conferences and everything, that essentially that has become a forum for talking about the U.S. meat processing systems and companies and what may need to be addressed that's going on in them at this point in time. I'm amazed by that. All right, now you all remember these red dates up here are to give us sort of a timeline. That's what's important about these slides for the most part. The executive branch attention to antitrust in the meat processing industry came to light around July of 2021 when the president, as many of the executive orders in his first few months, one was the executive order on promoting competition in the American economy. And it was for all sectors, not just ag, but accompanying on the same day was another sort of brief that supported the issuance of the executive order. And in that brief, there was an entire slew of factual statements and issues that this administration was declaring essentially to be their policy to try to address in the meat processing world. And you see some of the things that were being laid out there. They're highlighting that 4 beef packers now control 80% of the market, that antitrust enforcement had become very lenient in the last, they're saying, 40 years, and that federal agencies were bringing fewer antitrust cases. And it looks like it was in the last 4 years prior to this 2021, the number of cases had declined from 22 antitrust cases pursued by the Department of Justice down from an average of 60 in years previous to that. I guess it's across the previous 6 years. So that just gives you a little bit of reminder as to how some of this got started. And we talked about this last year. I shouldn't say got started. It's when the executive branch kind of jumped into what was already going on in the courts in the class action context. Later on that year in September, specifically September 8th, there was a policy outline, as they're calling it, saying that is titled Addressing Concentration in the Meat Processing Industry to Lower Food Prices for American Families. And, they were identifying issues that were leading to, at that time, food, price inflation, and, using phrases like corporate consolidation problem with meat processing giants, and that their priority was going to be stepping up antitrust enforcement. And specifically, this was, named by name, specifically for the meat processing industry, which again just highlights how sort of focused the White House, had become on this particular industry. Later on in that year, in December, there was another briefing of sorts that was interesting in the sense that I don't know if I want to call it rhetoric, and not in a bad way, but it's just simply, the language that was being used is very powerful. Here is the bottom line. The meat price increases we are seeing are not just the natural consequences of supply and demand in a free market. They're also the result of corporate decisions to take advantage of their market power in an uncompetitive market to the detriment of consumers, farmers, and ranchers, and our economy. And, that's pretty powerful stuff coming from the White House, particularly if you happen to be in the meat industry on the processing side. You start to feel like, there's a target forming on your back. Now, the White House also alluded to the fact that in September of 2021, says we also called for Congress to work together to enact greater transparency in cattle markets. And that was the issue of beef, operations and beef, breeders not getting the kind of prices that they felt were warranted, yet the price of beef was still going up in large increments in the store. However, nothing was trickling back to the to the producers, and so that obviously was causing a lot of attention. I'll skip over this slide because I need to make sure that I don't run out of time. There was more that went on in January. There was there was an entire sort of plan where the USDA and the DOJ were going to be developing a streamlined process for concerned producers to submit complaints regarding packers and stockyard and antitrust violations. So they were, committing to doing certain things jointly between the USDA and the Department of Justice, specifically in the meatpacking industry. And these numbered paragraphs tell you a little bit about not only new regulations for the Packers and Stockyards Act, deal with the product of USA labeling, which that one has not actually been dealt with yet, increased market transparency through more robust market reporting. All of these things were priorities of the administration to try to get to moving on in what is still more or less the first year of the administration. Hadn't quite hit, a one-year anniversary from Inauguration Day at the time of this, which was January 2 of 2022. Now, in terms of those things that the executive branch was saying were priorities to proceed with in terms of addressing anti-competitive conduct in the meat industry, they went ahead in February, the very next month, the beginning of this year, they went ahead and put together this online portal for complaints to be submitted to USDA and the DOJ with regard to conduct in the marketing of livestock covered or processed, proteins, and the so on this one, you could say the executive branch did what they said they were going to do, and they set up this process. Now, later in the year, in March, there was, you may recall that, we've had so many large pieces of legislation, but this was the Consolidated Appropriations Act of 2022. And in that act, there was specific money allocated to the setting up and maintaining of what's called a cattle contracts library as part of USDA's Ag Marketing Service, and also a swine contract library. So that gets to the issue of greater transparency and market reporting to assist producers, in marketing their livestock. And so you can say that the administration, at least followed through on setting this in place. How it's working, I'm not here to judge, but they put in place what they said they were going to do. Next, so what we're doing now is I'm essentially bringing you through 2022 and showing you what happened after those events at the end of 2021, where the White House was saying a lot but hadn't yet done anything. Now they're starting to do things through the year 2022. They also, of course, in October, towards the end of the year, not so long ago, they published a proposed rule to amend the Packers and Stockyards Act regulations. And so again, you can check the box here that they did exactly what they said they were going to do in some of those initial sort of policy statements with regard to their intent to get involved with anti-competitive conduct in the meat industry. All right. So that gives you a little bit of an idea of what the executive branch was up to. All right. Now, the executive branch wasn't the only one who was attempting to get involved in government action in this area. People are probably aware that Senator Chuck Grassley, this has been his issue for a very, very long time. This is the homepage of his website as a U.S. Senator. And what you see when you go to his homepage, right at the top, is this giant banner that says the beef with big cattle. And that is particularly the protein that he is very, very involved and concerned about. And he has had quite a history of pursuing these issues before most people were even talking about them. Now, this is a little list, which might be a little hard for you to see. Type's pretty small, but this is a list going all the way back to 2020 from his website, where he is essentially giving you the timeline of all of the things that he has done to try to bring greater transparency to the cattle industry, and all the way up to April of 2022. And curiously, it stops there. And I will explain why in a minute. Now, he essentially engineered, through the cooperation with other senators, 2 bills that were introduced in the 2020 legislative year. The first was called the Cattle Price Discovery and Transparency Act, which was a pretty complex idea, not particularly long in terms of a bill, but a somewhat complex idea that it was introduced in the Senate in April, but it was never brought up for a vote on the Senate floor after it was voted out of the Senate Ag Committee in July of 2022. So essentially, this effort by Senator Grassley failed, but it's important. It's instructive to see what he was trying to do. And by the way, the companion piece in the House the companion bill in the House never even got out of the House Ag Committee. It was introduced in May, as you see here. Now, what this bill was essentially attempting to do was the third paragraph here is just like the money that was included in the Appropriations Act, I'm trying to remember what the date on that was, but very close in time with the introduction of this bill, he was pushing for a statutory or a statutorily authorized and created and administered library of marketing contracts. Now, his interest was cattle only. However, we now know that the portion of the Appropriations Act that put this in place provided money for it, but didn't provide the details to the extent that he did in his bill. So he wanted it to be, more fleshed out. Let's just put it that way. And now there was other things in here that were somewhat, they were somewhat of a reach, and I think that's why it didn't go anywhere. Essentially, what he was attempting to do in a very summary way is he was attempting to define the various ways in which cattle would be marketed by producers, or probably better to say, cattle would be purchased by the processors, and then he wanted to create a certain minimum amount of transactions in fed cattle on the hoof that would be required, or it would be considered potentially a violation of, and this was not going to be the Packers and Stockyards Act, so it would be a violation of this particular act. But in any event, it was a somewhat intrusive idea that, well, we have some ways of or processors have some ways of buying cattle that lead to an ability to report more robustly on what kind of prices are being paid, for what type of cattle, and weights and grades and all of that, all of those things, and then make sure that people were required to use the type of purchase transactions that led to transparent reporting of the prices, and that's about as close as you can get to a description of it. So it was mandatorily requiring buyers in the cattle market essentially they could only buy so much cattle by certain methods, and they would have to have minimum quantities of cattle purchased in accordance with the levels that were set in this statute. So that was his way of trying to create transparency. Interesting concept. Perhaps easier to see why it may not have gotten anywhere, apart from general, maybe we'll call it legislative difficulties. I was going to say legislative dysfunction, but I'm not going to go there. So that was the bill that failed, that Grassley was pushing most of the year of 2022. The other bill that failed was one that he introduced called the Meat and Poultry Special Investigator Act, which again was introduced in March and never brought up for a vote on the Senate floor. However, interestingly, the companion bill actually did pass the House. So it did make it through one chamber at least. Now, this was a much simpler idea. It was simply to establish within the Department of Agriculture, Packers and Stockyards Division, a new prosecutorial office called the Office of the Special Investigator for Competitive Matters. And this was going to be essentially a prosecutorial function to enforce the existing laws through let's just say a in-house prosecutor in the USDA, rather than having things have to go to the Department of Justice, for example, and then there was going to be cooperation between the Department of Justice and this new special investigator for competitive matters within USDA. And essentially it was to say, okay, if the Department of Justice is too busy for this stuff, then let's create somebody at USDA who won't be too busy for it, or will be concentrating on it full time, let's just say, will be concentrating on essentially the livestock industry. So that again did not pass, but at least we'll say the legislative branch or some within it were seeing the need and attempting to do something. So over the course of 2022, the executive branch is moving on actions, and they believe that there is anti-competitive conduct in the protein sector that needs to be addressed by government, and that it's caused by consolidation and, I'll put it politely, opportunistic profit maximization. That's my way of being diplomatic. The legislative branch, not so convinced. They either were unable to act or they weren't convinced of the need for any action, as we know by the fact that both bills that Senator Grassley engineered went nowhere. Now we're going to turn to the judicial branch, which is what I told you we'd be talking about. And what they've been doing, and I like to look at sometimes problems that we have in this country as, what is each branch tried or not tried? And, different branches of government sometimes have a way of getting through on something and doing something about, a particular issue that the other branches cannot do for one reason or another. And in this case, we have civil class action being pursued by private attorneys that appears at this time to be making a lot more headway in a much more, in a much faster and much more convincing and remedial way, let's just say, with regard to the processors who are, whose conduct is under the microscope. And that's an interesting observation, just because we in this country have learned to demonize attorneys who litigate for a living, let's say. Yet, there is the social benefit of that. And this is an example where perhaps they're having much more effect than the other two branches are able to produce at this time. So these, again, are the three cases that I'm going to sort of orient you to, and then some other little things that surround those cases. Now, in-ray chicken antitrust, or excuse me, in-ray broiler chicken antitrust, generally is that case is for suits by individuals, entities, plaintiffs who purchased from poultry processors. Now, there is another antitrust, and this asterisk is what I'm getting at. There is an additional newer case that is working through the system, which I'm only going to talk about very briefly, which is all about broiler chicken contract growers and the antitrust or the anti-competitive conduct that they or their lawyers are alleging is occurring in that particular context. So there are two broiler chicken. One is just broiler chicken and one is broiler chicken grower. And the grower is very in its beginning stages. And so we are not going to talk about it now, but it'll be something that we're going to continue to compile information on, and it'll be on our website. And again, broiler started this in terms of the model for what's going on. Pork really imitated what the broiler chicken litigation is doing, and then cattle and beef sort of is doing its own thing, because they have a whole different way of selling and buying, and a whole different way of getting their livestock into the processing plant, let's just say. Okay, now what's all this about multi-district litigation? Well, there's an entire section of the federal court system which is devoted to multi-district litigation. Many of us probably went to law school for attorneys here when this wasn't even really on the radar. But they have their own website. It's called the Judicial Panel on Multi-District Litigation. And it's the cases are called MDL, but then the entity that administers this system is called the JPML. In any event, MDL is the only acronym I'm going to confuse you with here. It says here this is their mission, so it's probably good to read. The job of the panel is to determine whether civil actions pending in different federal districts involve one or more common questions of fact, such that these actions should be transferred to one federal district or coordinated or consolidated pretrial proceedings, and they select a judge or more than one judge who's assigned to conduct all of this pretrial proceedings. And many people may be very aware of the glyphosate products liability cases involving people exposed to Roundup and alleging that they contracted non-Hodgkin's lymphoma. That is one such example that is all being administered by one judge, Vince Cabria, or I believe is how you say his name, and he is in Sacramento, California. And I think that's Northern District of California, and all of the Roundup products liability that involves non-Hodgkin's lymphoma being the damages is administered by him at this stage and for all of the pretrial processes. And the same thing is going on with regard to these particular class actions in the poultry sector, or excuse me, in the protein sector. You know, the purpose of this transfer like this is, or what they're calling a centralization process, is to avoid duplication of discovery, prevent inconsistent pretrial rulings, and conserve the resources of the parties and their counsel and the judiciary. It makes a lot of sense. Yeah, and now it says transferred actions, meaning let's say that you started a case in, let's say but we'll get to it in a second, but a bunch of these cases are in the Minnesota District Court. And that's where the poultry and the pork is, I think. We'll get to it in a second. Too many things in my head at this moment. We'll get to it on the next screen even. And let's say that you filed one and you got shipped over there. Well, you'll be there. The transferred action is not, it doesn't go to its conclusion in the transferee district. And they are remanded back to their original districts if in fact they end up having to go to trial. So this is for the pretrial portions only, but it's again to create that consistency that I was just reading there. Now, this is very tough to see, but you can get all kinds of reports like this out of the multi-district litigation panel's website, and this is in fact excerpts of the various reports that show the cases we're going to talk about. One on the top is distributing them by district. So this is the Minnesota District Court up here, stuff depending on how big a screen you have. And then here is the in re pork antitrust litigation, second one from the bottom. And then you see the in re cattle and beef is also under the same judge, John Tunheim. The poultry, I couldn't, that's in a different place in the report. Yeah, I guess that's right. So it's in Illinois, sorry. But in any event, the thing I wanted to show you here is that over here on the far right, it tells you how many cases have been transferred under this umbrella, this multi-district litigation umbrella, where they will essentially be litigated up until the time where, if there has to be a trial, they go back to wherever it was that they were filed. So there's 18 in the cattle and beef antitrust litigation, and that can be 18 very large cases because they're class actions, most of them. And then there's 29 in the pork, which makes sense because the pork has been around a lot longer than the cattle and beef antitrust litigation. And then down here we have, this is a report by docket type. So I pulled out I ran a report on antitrust, and here you see an entry for the broiler chicken grower antitrust litigation. Long story short, I could not get the other one because of the way that the report was set up. But in any event, it's under this Judge Shelby. And that's the grower litigation is actually in the Eastern District of Oklahoma, is where the multi-district litigation is being administered. Okay, so that just gives you a little flavor, as to how does this stuff work and what's it all about? Because I know I was a litigator, but I did not do this kind of litigation. Now, couple of terminology issues before we get to talking about some of these cases. There are direct in the class actions. The classes that have generally been created are the defendants are all the big processors in the meat industry, which we'll see in a sec. The plaintiffs, if they end up getting certified as a class action, these are the common divisions that are used. Direct purchaser plaintiffs are essentially wholesalers who buy from, let's say, Purdue, and then, sell to grocery stores, for example. Or maybe the grocery store chains are buying directly from Purdue. So it could be grocery wholesalers, it could be retailers, direct purchasers who bought from Purdue in my example. Then there's commercial and institutional indirect purchasers, which are people that didn't buy from Purdue. They might have bought from the wholesaler, but they're buying a Purdue chicken whose price was allegedly artificially inflated through collusion among processors. They didn't deal directly with the processors, they dealt with the wholesaler, but they were still damaged because they paid the potentially illegally agreed upon price. Or the price that there was a conspiracy to keep that price higher than the market would have otherwise dictated. And then there are the end user consumer plaintiffs, or just the consumers, who, again, anytime you buy some chicken in the store, you're paying theoretically a price which these people are claiming has been illegally puffed up. Okay, here's the broiler chicken, antitrust litigation. I'll spend a little bit of time on this so that you understand what's going on here, and then we're going to get much more quickly through these. Now, DPP means direct purchaser plaintiff. So in the in-ray broiler chicken, and that's usually the lead, is these people who buy directly from the Tysons or the Purdue's or whoever it may be that is the processor. They are the logical first set of plaintiffs and they're usually the ones that the class action lawyers that pursue these, they're the ones that they sign up. Because they're the easy to understand relationship that, hey, I bought from Purdue directly, and the price I was paying was the subject of, a conspiracy and collusion to keep it artificially high and interfere with, the market processes. So the complaints are huge, 136 pages in this direct purchaser complaint. In the in-ray broiler chicken, 408 paragraphs. Who's the class in this one? The direct purchaser plaintiffs, all persons who purchased broilers directly from any of the defendants, and I'll show you a list of the defendants in a minute, or any co-conspirator identified in this action, or their respective subsidiary, from at least as early as January 2008 until the present, which the present in this particular case was 2016 when the complaint was filed. But in any event, these are long-running conspiracies that are being alleged to artificially inflate prices to the, again, processors artificially inflating prices to their customers. And so here's an example of the general allegations in the bullet here that plaintiffs allege that in order to maintain price stability and increase profitability beginning at least as early as January 2008, the defendants and their co-conspirators conspired to combine to fix, raise, maintain, and stabilize the price of broilers. The principal method, but not exclusive method, by which they did implement and execute their conspiracy was by coordinating their output and limiting production with the intent and expected result of increasing prices of broilers in the United States. In other words, they were talking to each other about keeping the supply down so the price would stay up. In furtherance of their conspiracy, they exchanged detailed, competitively sensitive, closely guarded non-public information about prices, capacity, sales volume, demand, including through third-party co-conspirator AgriStats. Now, in the AgriStats is like a business consultant who aggregates data, for marketers of, in this case, meat, and they were not named as a direct plaintiff in the broiler litigation. They were just a sort of unnamed co-conspirator, probably because they wanted them to potentially cooperate with the plaintiffs at some point. However, they are named in the others, it's particularly in the pork. Okay, now plaintiffs also alleged, that the defendants fraudulently concealed their anti-competitive conduct from the plaintiffs and the class in furtherance of this conspiracy. And as a result, there may be other methods by which they carried out this conspiracy, which are not presently known. So it's the catch-all phrase, clause to make sure that they can amend later and say, "Oh, we found out in discovery that you did this, this, and this that we didn't even know when we filed the complaint." So the defendants in this particular multi-district litigation, in this particular complaint for the direct purchasers of broiler chickens from all the defendants, essentially represent 90% of the entire wholesale broiler market. So let me just go forward here because I don't want to cut you short and run out of time. So here is a scorecard of what the heck is happening in this case. And you would not believe the amount of work that it took to compile something like this so that you can show it to somebody. No one has put this together but us, which is we're pulling from all of these little news items and news reports that you get in the ag press and the dockets. And we're pulling out where, who are all the defendants. And there can be, like I showed you that one statistic where there was 18 separate cases in the one type, the one MDL, and then there was like 40 some in the other. This is there in this particular, under this docket number, there are a ton of cases. This is just one of them. But here's the lineup you see of defendants. It's all of the largest poultry processors in the entire country. And here were the over here is who has settled with them. And this is the gold right here because this information is not available from anybody else but us, all in one place like this. Some of the smaller ones have settled. We don't even see Pico Foods around here. I don't know what that is. George's defendants, there's a George's Farms, which is apparently a poultry processor somewhere in the country. Amick Farms, Pilgrim's Pride, we all know that name for the most part, and of course Tyson. Here are the respective amounts that they have already paid to the direct purchaser plaintiffs to settle and get themselves off the hook here with regard to colluding to artificially inflate the wholesale price of broiler chickens to their customers. By all of these people on the right-hand column communicating with each other to ensure and to mutually enforce against each other in ways that have real effect, that if you don't control your supply, then we're going to come after you, and then we'll undercut you. And this stuff was going on, if you believe what is said in the complaints, it was going on for years and years, and it was going on very, very overtly. And now, if you total all this up, you'll see a very sizable amount of money, obviously, well in excess of, 300 million. Yep. Nobody's paying $300 million for something that they weren't really, really scared they were going to get caught, doing. Particularly when you look at the market share that Tyson has and the money that they're paying, but Pilgrim's Pride also. And then these people, the first three are obviously small players. So this is essentially the gist of what we've been able to pull together through a lot of painstaking work to make sense of this stuff, because we were like everybody. We would read these articles and say, oh, another person, settled, how many does that make now? There was no way to figure that out. So that's why we did this in our agricultural antitrust litigation tracker. Now,
Brooke, I'm just gonna interject just to remind the audience, if you have any questions, please enter those in the Q&A feature. Thanks. Okay, Brooke. Okay,
so now we'll look at the indirect purchaser plaintiffs, the IPP. These are those who didn't buy from Tyson or Coke Foods or Pilgrim's Pride or Purdue. They didn't buy broilers, but they bought them from some, let's say, a wholesaler that had bought them from these entities. There have been no settlements there yet. So that kind of serves what I had said before, which is the direct purchasers are the logical first place that these cases, if they're going to get settled or they're going to go to trial, or, the plaintiffs know that that is the case that is going to make the easiest presentation and be the easiest to prove. And so that's where the attention is. We haven't got in this world, in this multi-district litigation, we haven't gotten to the indirect purchasers yet. At least that has not been developed to the point where anyone's ready to settle those claims. But those could come down like a waterfall someday. Now, the other category would be consumers. And again, that is very, very hard sledding for a class action attorney because of the, how do you distribute them? It's all that rigmarole that you end up having to do when you have a class action. That is, talking about sending out individual checks to participate in the class action settlement. That's a tough way to go. These other, categories of plaintiffs are much easier to deal with. But there has been one settlement. This George's Farms, for whatever reason, decided that they wanted to get out of this on the consumer side too, and they got out of it relatively inexpensively, let's say. So there's been one settlement there. Again, this took an amazing amount of work to put together. And Chloe Marie, who is you will hear from later on, she is the one who did most of this work. So here's another antitrust case that you might have heard something about. This is not a class action, but it's somewhat interesting. This is an example. This is Chick-fil-A. They were under the multi-district litigation because they obviously buy a lot of chicken. And they, but they were just a single plaintiff, but they got put into the multi-district litigation too, because they had the same issues, the same proof, the same, discovery problem, all the same things. So they were a logical fit. Well, they wanted out. They wanted to settle. They did not want to be part of any of these other classes. They wanted to pursue it themselves and get in, get out, and serve their interests and not be part of these other classes that might be created that would cover them, which would probably be the indirects, because they'd be an indirect purchaser plaintiff because they probably buy from some kind of middleman of some kind. So they settled with Tyson already, and I know there's a dollar figure here someplace. Oh, okay. This is one where the settlement agreement are under seal. So there is no information right now about exactly how much was paid. But this is an example of somebody who's in one of these multi-district litigation umbrellas, so to speak, who decides to go it alone and get out. And so they were able to do that. And hopefully they're happy with the with the settlement that they got. This is an example, just some information. And again, it really helps if you get the PowerPoint because I have lots of links in here. Coke Poultry, I think is how you say it. They settled in the grower class. Where I was telling you, there's the in-ray broiler chicken grower antitrust litigation. Coke settled with let's see, the plaintiffs. Let's see. The plaintiffs' attorneys will have to set up the process for the class of growers that are involved in this particular litigation to participate and receive their settlement proceeds. So this is also under this umbrella and is going on just in the grower context, which again is in Oklahoma, I believe. And yeah, here it is. And this also, in addition to Coke, let's see, Coke paid $15.5 million in the grower litigation, the grower to get out. Tyson paid $21 million and Purdue paid $14.75 million. So that's who has settled in this particular litigation so far. All right, I'm going to whip through a few of these. This is the pork antitrust litigation. I'm showing you the table of contents of the complaint. which is again another one of these 400 or 500 page or paragraph complaints. This tells you all you need to know about what the pork people are saying. It's the same thing as the poultry people. The defendants' anti-competitive scheme started from AgriStat's central role in collusion in the broiler industry. So that's why this one kind of let out of the other one, because they realized that AgriStats is being used, their data and their personnel are providing the same services in the pork industry that they were providing to the broiler industry, and the same type of collusion is going on. So after their success in the broiler industry, AgriStats began marketing this collusive scheme to the swine integrators. AgriStats provided pork integrators unparalleled ability to monitor pricing and production, et cetera, et cetera. The defendants, and I'll show you the laundry list, controlled the entire supply and production of pork in the U.S., which allowed this, scheme to succeed. And so essentially you see that you don't even have to read the intricate complaint or allegations of the complaint. They're the same as the poultry case. It's exactly the same thing going on. They learned it from the poultry people. And so here's the scorecard. You can't tell the players without a scorecard. Forget the original plaintiffs, and these are taken right from our website. I'm actually cutting this. Those are sort of how you originally draft your complaint, but then when you settle, you can go in and say, okay, we're under this complaint, but we're a different set of plaintiffs. So the direct purchaser plaintiffs, that's who these people are, but it's also a class of anyone similarly situated. So far, there has been a JBS settlement for $24.5 million and a Smithfield giant for $83 million. So and here's the laundry list of the defendants on the pork side. So we know there's been two settlements, or two defendants have decided to the heat is getting hot and they want to get out of this with regard to at least the direct purchaser plaintiffs.
And
all right,
we are at 1 o'clock, or a minute before 1.
I got a minute.
We'll just have to go this last slide.
All right. Well, let's see. I mean, we can just delay the break if we want for 5 minutes or so. This is the indirect purchaser scorecard here, and we also have settlements there. Smithfield and JBS have settled. Trying to remember, yeah, same two as you see down here in the bottom left-hand corner. Same two defendants have settled with regard to the indirect purchasers, meaning like the wholesalers. And then on the pork side, also the same two have already begun to set up a consumer class action settlement whereby consumers can participate. And, you, me, and anybody else who bought some pork that came from any of these people is potentially within the class. So that's how this is working. Now, cattle is different. Cattle industry is different than pork and poultry. And so it's set up a lot differently. The major problem in the cattle litigation is that the dockets are generally sealed. Chances are you're going to have a sealed docket with confidentiality orders, or you're going to have sealed pleadings. And that's just because the beef industry, the beef processors, by this point in 2020, when this one started up as the third one, they got wise to the idea, I would assume, that they could get, confidentiality orders and get sealed pleadings and sealed dockets. But this does cover, this multi-district litigation does in fact cover cattle on the hoof, like fed cattle, or carcass or box beef that's already been, essentially, packaged for, for butcher, at the, grocery store level or at the retail level. So there is a whole world of beef, potential beef plaintiffs in here. And, you see it's a little bit small, but you can see who the defendants are, all the big beef processors. And so far, JBS has in fact settled. We know that they settled. We don't know a whole lot about details because so much of it is sealed. But that gives you an idea as to essentially what's going on. Now, a couple more slides. This is a slide, and I'll wrap it up. This is all about a case that is sort of an offshoot. This is not the poultry sector involving price collusion. This is involving poultry processing plant worker wage collusion. And this has already begun to generate settlements. Here you go. In this particular case, Cargill paid 15 million, Sanderson paid 38.3, and Wayne, who I'm not sure that I even knew there was a Wayne, poultry processor, 31.5 million has been paid. So they're beginning to settle too. So that just shows you that there is, the poultry, or excuse me, the protein sector is, got more than just price collusion to worry about. At least in the poultry context, they're getting hit with class actions about their processing plant workers' wages being the result of artificial suppression. So that is it for this particular hour, and we will adjourn until.
Yes, so Brooke, we'll go ahead and take a break and come back at 2:15. So thank you all, and we'll see you in about 12 minutes.